If you've been hearing that the I-130 petition process is being completely eliminated, that family-based immigration is ending, or that you won't be able to sponsor your spouse, parents, or children anymore, I need you to take a deep breath because there is so much confusion and misinformation circulating right now that is causing unnecessary panic in immigrant families across the country. You are not alone in feeling worried. You are not wrong to want answers. But what you're seeing on social media and what is actually happening in U.S. immigration law are two very different things. Today, we're going to walk through exactly what is being proposed, what is actually law, what has changed and what has not, and most importantly, what this means for you and your family right now. Stay with me because the truth is more nuanced than the headlines, and understanding the facts will help you make the right decisions for your situation. Let's start with the foundation. The I-130 petition, officially called the Petition for Alien Relative, is the form that U.S. citizens and lawful permanent residents use to sponsor certain family members for immigration to the United States. This is the backbone of family-based immigration. It's how American citizens bring their spouses, children, parents, and siblings to live in the United States permanently. It's how green card holders sponsor their spouses and unmarried children. Family-based immigration has been a core part of U.S. immigration law for decades, and it is established by federal statute in the Immigration and Nationality Act. This is not a program that was created by executive order or administrative policy. It is written into law by Congress. Now, here's what you need to understand about how changes to immigration law actually work in the United States. The President of the United States has significant power over immigration enforcement, border security, and certain administrative aspects of the immigration system. The President can issue executive orders that direct how agencies prioritize cases, how they allocate resources, and how they interpret certain regulations. But the President cannot eliminate statutory programs that were created by Congress. The President cannot simply decide that family-based immigration is over. The categories of family-based immigrants, the quota numbers, the eligibility requirements, and the fundamental structure of the I-130 process are all established by federal law passed by Congress. To change those things would require new legislation, which means a bill would have to be introduced in Congress, passed by both the House of Representatives and the Senate, and then signed by the President. That is a lengthy process with many steps, and as of right now, no such legislation has been passed. So, what is actually being discussed? There have been statements, proposals, and policy discussions about reforming the family-based immigration system. Some of these proposals include limiting which family relationships qualify for sponsorship, eliminating or reducing certain visa categories, implementing stricter financial requirements for sponsors, creating point-based systems that prioritize certain skills or characteristics, and making changes to how visa numbers are allocated. These are proposals. They are ideas that are being discussed. Some of them have been included in draft legislation, some of them have been mentioned in policy platforms or campaign materials. But as of today, in January 2026, none of these proposals have become law. The I-130 process still exists. Family-based immigration is still available. The law has not changed. What has changed, and what is continuing to change, is how immigration agencies are processing cases, what their enforcement priorities are, and what policies they are implementing within the framework of existing law. For example, USCIS, which is the agency that processes I-130 petitions, can change its processing times, its fee structure, its evidence requirements, and its adjudication standards within certain limits. These changes can make the process slower, more expensive, or more difficult, but they do not eliminate the process itself. Similarly, the Department of State, which handles visa applications at consulates overseas, can implement new administrative procedures, increase scrutiny of certain types of cases, or change interview requirements. These changes can affect how long it takes to get a visa and what documentation you need to provide, but they do not change the fundamental eligibility categories. Let's talk specifically about what family members, U.S. citizens, and green card holders can currently sponsor, because this is where a lot of confusion exists. If you are a U.S. citizen, you can sponsor your spouse, your unmarried children under 21, your unmarried children over 21, your married children of any age, your parents if you are at least 21 years old, and your siblings if you are at least 21 years old. These are called immediate relatives and family preference categories. Immediate relatives, which include spouses, unmarried children under 21, and parents of adult U.S. citizens, do not have to wait for a visa number to become available. Once the I-130 is approved and the beneficiary completes all the required processing, they can immigrate immediately. Family preference categories, which include unmarried adult children, married children, and siblings, are subject to annual numerical limits, which means there is often a waiting period before a visa number becomes available. If you are a lawful permanent resident, meaning you have a green card, you can sponsor your spouse and your unmarried children, regardless of their age. However, because you are not a U.S. citizen, your relatives fall into family preference categories, and they will have to wait for a visa number to become available. The wait time depends on which country they are from and which preference category they fall into. For some countries and some categories, the wait can be many years. Now, one of the proposals that has been discussed is eliminating or limiting certain family preference categories. For example, some proposals have suggested eliminating the category for siblings of U.S. citizens, or eliminating the category for married children of U.S. citizens. The argument behind these proposals is that they would reduce the overall number of family-based immigrants and prioritize closer family relationships. However, as I've said, these are proposals. They are not law. If Congress were to pass legislation eliminating certain categories, it would likely include transition provisions for people who already have pending petitions. In past instances where immigration categories were eliminated or changed, people who had already filed generally had some form of protection or grandfathering, although the specifics varied depending on the legislation. Another area of discussion has been the financial requirements for sponsors. Currently, when you file an I-130 and the beneficiary applies for an immigrant visa or adjustment of status, you must also submit an affidavit of support, which is Form I-864. This form requires you to demonstrate that your income is at least 125% of the federal poverty guideline for your household size. The purpose of this requirement is to ensure that the immigrant will not become a public charge. Some proposals have discussed increasing this income requirement, requiring sponsors to have higher levels of income or assets, or imposing additional financial obligations on sponsors. Again, significant changes to the affidavit of support requirements would require legislation, although USCIS does have some ability to change how they evaluate financial evidence within the existing legal framework. There have also been discussions about implementing stricter vetting and security checks for family-based immigration cases. This could mean longer processing times, more extensive background checks, additional interviews, and higher denial rates for cases where there are any concerns about fraud, security, or eligibility. These types of changes can be implemented through agency policy and do not require new legislation. So if you are in the process of sponsoring a family member, or if you are planning to do so, you should be prepared for the possibility that the process may take longer and may require more documentation than it did in the past. Let me be very clear about something that is causing a tremendous amount of fear right now. Some people are hearing that if they file an I-130 now, it will be rejected or denied because of new policies. That is not accurate. If you are eligible to file an I-130 under current law and you submit a complete and properly documented petition, USCIS is required to adjudicate it according to the law. They cannot simply reject your petition because they don't like family-based immigration or because there are proposals to change the system. They have to apply the law as it exists. Now, that doesn't mean every petition will be approved. USCIS can and does deny petitions if they find that the relationship is not genuine, if the petitioner doesn't meet the eligibility requirements, if there is fraud or misrepresentation, or if the beneficiary is inadmissible for some reason. But those are legal grounds for denial based on the specific facts of your case, not blanket policy decisions. If you are currently in the process of sponsoring a family member, here's what you should do. First, if you have already filed an I-130 and it is pending, monitor your case regularly. Check your case status online, respond promptly to any requests for evidence, and make sure USCIS has your current address. If your I-130 is approved and your relative is waiting for a visa number, keep track of the visa bulletin each month to see when their priority date becomes current. If your relative is going through consular processing, make sure they attend all required interviews and medical exams and provide all requested documentation. Second, if you are planning to file an I-130 but have not done so yet, and you are eligible to file under current law, you should seriously consider filing sooner rather than later. While it is impossible to predict exactly what changes might happen in the future, having a petition filed and a priority date established can be important if there are changes to the law. In many cases, when immigration categories are eliminated or restricted, people who have already filed petitions may have some protection or may be grandfathered into the old system. There are no guarantees, but having a petition on file is generally better than waiting. However, you should not file a fraudulent petition or a petition you are not eligible to file just because you are worried about future changes. Filing a fraudulent petition can have serious consequences, including criminal charges and permanent immigration bars. Third, if you are a green card holder and you are eligible to become a U.S. citizen, you should strongly consider applying for citizenship. As I mentioned earlier, U.S. citizens have more options for sponsoring family members than green card holders do. If you naturalize, your spouse and unmarried children under 21 become immediate relatives, which means they don't have to wait for a visa number. Your unmarried adult children move to a different preference category with shorter wait times, and you gain the ability to sponsor your parents and siblings. Becoming a U.S. citizen also protects you from deportation and gives you voting rights and other benefits. If you have been a permanent resident for at least 5 years, or 3 years if you got your green card through marriage to a U.S. citizen, and you meet the other requirements for naturalization, applying for citizenship is a smart step. Fourth, make absolutely sure that your I-130 petition is properly prepared and fully documented. One of the ways that USCIS can make the process more difficult without changing the law is by being more strict in how they evaluate evidence and by issuing more requests for evidence or notices of intent to deny. To minimize the risk of delays or denials, make sure you include strong evidence of the relationship, such as marriage certificates, birth certificates, photos, joint financial documents, and affidavits from people who know you. Make sure your affidavit of support is complete and shows sufficient income. If your income is borderline or if you have a large household size, consider adding a joint sponsor. Make sure all translations are certified and all documents are clear and legible. If you are not confident in preparing the petition yourself, consider working with a qualified immigration attorney. Fifth, be very cautious about making any misrepresentations or providing false information. In a climate where there is increased scrutiny of immigration cases, USCIS and the State Department are more likely to investigate cases that seem suspicious or inconsistent. If you provide false information on your petition or in your application, even if it seems minor, it can result in a permanent bar from immigration benefits. Always tell the truth, even if the truth is complicated or makes your case more difficult. An experienced immigration attorney can help you present difficult facts in the best possible light while remaining truthful. Now let's talk about what happens if you are outside the United States and you are waiting for your immigrant visa. If your I-130 has been approved and your priority date is current, you will go through consular processing at a U.S. embassy or consulate in your home country. The consular officer will interview you, review your documents, and make a decision about whether to issue your visa. Consular officers have broad discretion, and their decisions are very difficult to challenge. Some of the proposals that have been discussed include giving consular officers more authority to deny visas based on security concerns, ideological grounds, or public charge concerns. While these proposals have not been fully implemented, it is possible that consular officers may be applying stricter standards in some cases. If your visa is denied, you should receive a written explanation of the reason for the denial. Depending on the reason, you may be able to overcome the denial by providing additional evidence or by applying for a waiver. If you are in the United States and you are eligible to adjust status, meaning you can apply for your green card without leaving the country, you should understand that the adjustment of status process can also be affected by policy changes. USCIS can change its processing times, interview requirements, and its standards for evaluating cases. If you are adjusting status based on an approved I-130, make sure you file a complete and well-documented adjustment application. Include all required forms, fees, medical exam results, and supporting documents. Attend your biometrics appointment and your interview if one is scheduled. If you are asked to provide additional evidence, respond promptly and thoroughly. It's also important to understand the difference between changes that affect new applications and changes that affect people who are already in the system. In most cases, if you have already filed your petition or application and it is being processed under current law, you have some protection from retroactive changes. Immigration agencies generally apply the law as it existed at the time you filed, although there are exceptions to this rule. New policies and regulations can sometimes be applied retroactively, especially if they relate to eligibility criteria or grounds of inadmissibility. This is another reason why having a knowledgeable immigration attorney is so valuable. An attorney can help you understand how changes in the law or policy might affect your pending case. Let's also address the question of what happens if you are already a green card holder and you are worried about how these changes might affect your status. If you obtained your green card through a family-based petition and your green card has already been issued, you are a lawful permanent resident. Changes to the family-based immigration system do not affect people who are already permanent residents. Your green card does not expire just because the law changes. However, as I discussed earlier, green card holders can be placed in removal proceedings if they commit certain crimes, engage in fraud, abandon their residence, or meet other grounds of deportability. If you are a green card holder, make sure you maintain your status by living in the United States, avoiding criminal activity, and complying with all laws. And again, if you are eligible for citizenship, apply for it. Now, I want to address the emotional toll that all of this uncertainty takes on families. If you are a U.S. citizen or green card holder who is trying to reunite with your spouse, children, or parents, the process is already difficult, expensive, and time-consuming. The idea that the rules might change in the middle of your case or that the option to sponsor your loved ones might be taken away entirely is terrifying. I understand that, and I want you to know that your feelings are valid. But I also want you to know that the immigration system, despite all of its flaws and complexities, is built on laws that cannot be changed overnight. Family-based immigration has been a part of American law for generations, and it has survived many different administrations and many different political climates. While it is certainly possible that Congress could pass legislation that restricts family-based immigration, such legislation would face significant opposition and would take time to move through the legislative process. In the meantime, the current law remains in effect, and you have the right to use the processes that are available under that law. If you are feeling overwhelmed or uncertain about what to do, the best step you can take is to consult with a qualified immigration attorney who can review your specific situation and give you personalized advice. Every family situation is different. The timeline for your case, the country your relatives are from, their age, their relationship to you, and many other factors all affect what options are available and what strategies make sense. An attorney can help you understand how current law applies to your case, what risks you might face, what opportunities you might have, and what steps you should take now to protect your family's future. Let me also remind you that the information in this video is general information about U.S. immigration law. It is not legal advice, and it should not be relied upon as a substitute for consulting with an attorney about your individual case. Immigration law is complex, and the consequences of making mistakes can be severe. If you have an I-130 petition pending, if you are planning to file one, or if you have any questions about family-based immigration, please speak with a licensed immigration attorney who can give you accurate, case-specific guidance. So let's summarize what we've covered today. The I-130 petition and family-based immigration still exist under current U.S. law. No legislation has been passed eliminating these programs. There have been proposals and discussions about restricting or reforming family-based immigration, but proposals are not law. Changes to the statutory framework of family-based immigration would require action by Congress, not just executive action. What can change and what is changing is how agencies process cases, what their priorities are, and what policies they implement within existing law. If you are eligible to file an I-130, you should consider doing so sooner rather than later. If you are in the middle of the process, stay on top of your case and respond to all requests promptly. If you are a green card holder eligible for citizenship, apply. And most importantly, consult with a qualified immigration attorney if you have any questions or concerns about your case. Family-based immigration is one of the most fundamental ways that families stay together and build their lives in the United States. It is worth fighting for, it is worth understanding, and it is worth protecting. But the way to protect it is not to panic or to believe everything you see on social media. The way to protect it is to stay informed, to understand your rights, to follow the law, and to work with professionals who can help you navigate the system. If this video helped you understand what is really happening with I-130 petitions and family-based immigration, please subscribe to USA Visa Today. We are committed to providing you with accurate, fact-based, non-alarmist information about U.S. immigration law and policy. Share this video with your family members, friends, and anyone else who might be confused or worried about these issues. Accurate information is one of the most powerful tools we have against fear and misinformation. And if you have questions about I-130 petitions, family-based immigration, sponsorship requirements, or any related topics, please leave a comment below. We read every comment, and your questions help us create the content that you and your family need. Thank you for watching, and remember, stay informed, stay calm, and always seek professional legal advice when you need it. Claude is AI and can make mistakes. Please double-check responses.